Commonwealth versus Cargill.
Ms. Eisenberg.
Good morning, Your Honors. Beth Eisenberg for Ricardo Cargill. I would hope that from the tenor of our brief that this Court is of the view that, short of inaction, anything would be an improvement over the situation that is typified by the facts in the case before the Court this morning, and typified also by the uncertainty that's inherent in the questions of law that were reported by Judge Laureate. This case comes before the Court on the issue of the absence of any guiding language in Section 58, Paragraph 3 of Section 58 of Chapter 276, concerning the procedure to be followed at the expiration of a bail revocation order entered pursuant to Paragraph 3 when both cases remain pending. And it raises a number of extremely important questions before the Court today. Probably chief among them is, what happens to the original bail order? Did the legislature intend it to be extinguished, as the government argues, or is it temporarily suspended for a certain period of time, as we suggest? What court is empowered to take action on the expiration of a revocation period? What's the nature of that action?
What do you say is which court has the obligation to expedite the trial of a case?
Well, that is a good question, and in fact, it's not clear. I would say that there's some ambiguity there because, after all, this section is directed to the powers of the district court.
So if there were a murder case, for instance, in the Superior Court that was scheduled to be tried like 90 days away, and there's a bail revocation in the district court, does the obligation then shift to the Superior Court to move the murder case up 30 days?
I think that's a good example of why it is not clear under that language, and I'm not sure that the legislature intended it to be a mandate to any one particular court.
Do you think the burden is on the revoking court to try its case within 60 days?
I do, and the reason that I do is because that requirement is set forth in Section 58, and Section 58 directs itself exclusively to the jurisdiction of the district court, and I think it would be anomalous.
But a separate bail has been set in the second new case.
Maybe.
No, well, in all the cases that we have before us, a second bail, and then I assume that is typical.
Although I think I'm sorry, Justice.
I just think that since all three cases have that scenario, we can presume that that's the likely scenario, that a new bail is set in the new case and bail is revoked on the prior case.
It may be. It may be. And in fact, I think in our case, my recollection is that at least in the first instance, when this defendant's bail was revoked the first time, I'm not sure. I'd have to refresh myself and look at the facts. I know that bail was set at least once in the district court. The second time in the district court, there was a bail of $4,000 set, concomitant with the revocation.
Well, what are your arguments for which court should set the bail when the 60 days are up?
Well, I think that under the statute, the way I suggest that this statute works is that bail is set ordinarily to assure the presence of the defendant. And the court that set the bail made that determination. There was a full hearing, presumably, where all of the factors that are set out in Section 58 or Section 57, as the case may be, were deliberated on, and the judge said either didn't admit the defendant, didn't release the defendant on his own recognizance, so set a bail consistent with the factors that he heard. Now the defendant is out, and he picks up another case, and Paquette says that this is viewed as a kind of contempt of court order in terms of revocation, the thinking being that the defendant was warned that if he picks up another case, he may go back to jail.
So after 60 days, the defendant is not tried on any case.
Right.
Does the original bail automatically get reinstated?
That's our position.
How can it? The original bail was revoked. There's nothing to reinstate. It isn't a mystical thing that's out there somewhere. It was revoked, which means to me, the legislature used the word revoked. That means it doesn't exist anymore.
It's revoked for up to 60 days.
But revoked means it's gone.
Is the bail returned? The bail's not returned.
The bail's not returned.
Returned.
There's no forfeiture. The surety's not discharged. There's nothing in the statute that says, and at the expiration of the bail revocation order, the defendant shall be returned to the issuing court, whereupon there will be a hearing, blah, blah, blah. There's none of that. And there's every reason to think, based on the language of the statute.
But the statute doesn't say the bail will be suspended. They could have said that.
It's true, but there's I've cited in my brief at footnote 7, there's a United States Supreme Court case that also has dealt with this question of, well, when does revocation mean extinguishment and annulment, and when does revocation mean holding something back in temporary abeyance? And you got to look at, some terms are very clear and straightforward, and some are not, like the word shall. This Court has said sometimes the word shall is directive, sometimes the word shall is mandatory. You look at the context of the statute, and here the context of the statute is this person has picked up another case. The judge, amongst all the repertoire of responses that he has to this situation, can revoke the bail. But if he revokes the bail, and if he finds that the only reason this person is no longer bail-worthy is because he's picked up a new case, the countervailing requirement placed upon the government is get going and try the guy. And I'm not sure whether it's get going and try the guy in Superior Court or get going and try the guy in the foreign district court where the bail was originally issued, or get going and try him here in this court. I don't think it's clear.
Okay, you still haven't answered my question that I asked you, though, about 5 minutes ago. Which court should then have a hearing to set a new bail?
Well, but
should it be the district court or the Superior Court? Make it easy.
Well, I don't think a new bail hearing should be. I think
You're saying that you think the other bail just automatically reappears.
Reinstates.
The revocation order expires. The prior order is reinstated by operation of law.
That is our position. And it seems to me that if there's a change, there is no change in circumstance. I mean, the change in circumstance is what prompted the revocation.
Well, so can the original court, let's say after 60 days, can the original court then say, I want you up here, summonses the defendant in for a bail revocation hearing,
right,
and says 60 days has passed, you violated one of the conditions of your bail by committing another crime, probable cause has been found, I'm going to revoke your bail under my own powers, citing Paquette.
Well, I think under those circumstances, the public interest has been served by the initial period, and I don't agree that it has to be 60 days or adjudication.
How can the public interest have been served? Because if this person is so dangerous that the person deserves to have bail revoked, then his or her dangerousness doesn't change from day 60 to day 61, and wouldn't the Commonwealth be back in Superior Court on every single case when the 60 days expires saying, Superior Court judge, we have a changed circumstance here, which everybody would agree is a changed circumstances. Defendant committed a new crime since you issued your bail order. So because of this probable cause been found that he or she has committed a new crime, therefore the bail, instead of being $100,000, he should be held without bail, or whatever.
Paquette says that the fact that the public may get some benefit from the fact that someone is being held because they're dangerous is not the point of revocation. The point of revocation is in the nature of a contempt order. It's to remind and impose upon the defendant in no uncertain terms that an order which carries conditions with it has to be obeyed.
Correct, but the Commonwealth can always go back before one judge and say there were changed circumstances, the defendant has, probable cause has been found, the defendant has committed a new crime, we request an increase in bail. And
I think what the statute allows a reading for, and certainly under the principles of lenity would require the reading, is that that's what that revocation hearing, that is the interest that the revocation of the bail, the hearing on the revocation of the bail
satisfied. And according to you, it ends, that interest ends after 60 days. It magically ends.
It ends. And if either party wishes to come back before the court of original jurisdiction to point out any changed circumstances, not these circumstances, because these circumstances have been dealt with by the power of the court. It could be that after 60 days, whatever it was that warranted the judge's view that this defendant is dangerous has dissipated considerably. It could be that the Commonwealth's case has...
How could it dissipate? He's been held, so of course he didn't commit another crime because he's been incarcerated for 60 years.
But whether he's dangerous is based on probable cause to arrest, and presumably everybody's doing their job and is investigating.
He might have committed another crime in prison.
Can't?
No, I mean, people do commit crimes in prison. He may have violated a prison order. He may have, may not have been a crime, but somebody coming in saying this is,
Wouldn't the second court have the authority at that point to set bail? I mean, let's say, the district court is using a theft of a car or using it without authority, they set the bail. Then he commits a vicious armed robbery, and the Superior Court judge says, and then the district court revokes the bail. So he's now 60 days. And the 60 days go by, he hasn't been tried in either place. Wouldn't the Superior Court at that point say, look, we got to set bail on this guy and set a new bail on him? This guy isn't going to walk out at that point.
If the court wishes to recall that case back and have another hearing, or either party brings to the attention...
The DA is going to come in with a motion saying, I want bail set on this guy.
And our position is that the default is back to the original bail, and whether or not bail gets increased, that original bail gets increased, or stays the same, depends upon whether...
Can't the Superior Court judge says, well, the original bail is now gone, I'm going to set new bail?
Well, my position is based on a reading of the statute that the original bail is not gone.
But how can the original bail be reinstated?
I take it that if we were to agree with you, that it's not an extinction of the bail, it's a form, the revocation in the statute doesn't mean extinction of the bail with a return and, of the surety and so on and so forth. It's a suspension for 60 days. If we were to agree with you, then it would not be possible for the Superior Court judge at the expiration of 60 days to take a look at the bail, to consider bail, because in effect it would be the Superior Court judge reviewing the bail order of the district court judge in violation of Delaney?
No, at the end of it, your position is that it automatically reinstates itself. So obviously the Commonwealth can have the defendant brought back before the Superior Court
Right.
on a motion to increase the bail on the original charges.
Right,
because
and the motion to increase the bail has to be, the essence of bail is this person going to return to court for trial on the merits?
But how can you reinstate the bail when the bail was set on record A, and now you have record A plus probable cause to believe he's committed a new crime?
Right.
So you can't reinstate a bail that was set without the additional factor being known. It doesn't make any sense.
You can, the action that is taken...
suppose the new crime is rape, is some sort of a gang rape or something. You're going to say that the original bail on an armed robbery should be reinstated when the judge didn't know that the probable cause had been found to believe that he was involved in a gang rape?
All I'm saying is that I'm not suggesting that it cannot be, that the bail cannot be revisited on a proper proffer of facts that would warrant modification of the bail up or down.
But reinstatement doesn't make any sense when the circumstances have changed.
Why can't the two courts set separate bails?
Exactly.
Hypothetically, district court, going with the example, auto theft, okay, bail, whatever. Superior Court later, armed robbery. Why can't, when he's arraigned at the armed robbery, the judge say, look, maybe the Superior Court's going to revoke your bail, maybe they've revoked it, that's good for 60 days, but I'm separately setting bail on this armed robbery of $100,000, cash.
Well, that's
exactly what happens.
Yeah, and that's
exactly what happens.
Paquette sort of gives a, at the end of Paquette, I read the language to say, don't forget to set bail.
So you set bail on the new case, of course, and then the issue is the revocation of the bail on the old case. So both can be done and are, based on the record we have here.
And are.
Okay.
I think that if the court agrees that bail is reinstated, then then any number of different options are available. When the I think what the court, I would suggest what the court has to address is what happens at the expiration of that 60 days, apart from who's got the power to do it. Because if the court decides that it doesn't get reinstated, it has to be...
Do you agree with the Attorney General, and again, we've got three cases here, do you agree with the Attorney General that one thing that does not happen is that the accused walks out without bail?
At the end of the 60th
60
day? Without bail. Right. There is, I think that there is a reinstatement.
That much, at least you
There's
agree.
a floor, right. And I think the question becomes, where do you send this defendant? Do you send the defendant, there has to be some process and it has to be uniform so that these defendants, as the defendant here, it's not sitting and languishing for 2 days or 3 days or 7 days or 6 days waiting to see where he's going to land in order to be heard again.
You've never given me an answer whether, because you insist that it be reinstated. If we say it shouldn't, it isn't reinstated, is it your preference he goes back to district court or superior court?
Well, if it's not reinstated, then I don't see how the district court can deal with a bail that's set in a superior court.
So it would be the first court, it would be the first, the
issuing
original
court.
Okay.
Yes.
And if it happens on the weekend, if it's automatic and it happens over the weekend, does the sheriff, who's got a minimus holding him on bail, unrevoked bail, does the sheriff let him go on the original bail?
Well, that was my argument, if the court agrees that it's reinstatement. If the
And
court
Mr. Zanini
disagrees
is
that
just
it's not
about to
reinstatement. I'm sorry?
And Mr. Zanini is just about to tell us why that is incorrect. Correct, Mr. Zanini? Thank you, Ms. Eisenberg.
You're welcome.
Good morning.
Mr.
May
Zanini.
it please the Court. John Zanini for the
I hope
Commonwealth.
you're going to tell us the simplest way to deal with these problems.
He's going to tell us to
Because it could
dismiss
be
the appeal.
complete chaos if we get involved in some metaphysical world of what revives and what doesn't revive and all that stuff.
I agree, and it is complete chaos right now. We've brought a number of 211-3 petitions. Several of them are currently stayed, I think, pending the outcome of these cases. These are, every day we have one judge undoing the work of another judge, certainly at the district court level. So we do have a bit of chaos right now. I think that, and I'll try to stick with the Cargill case, the first issue, which I just want to mention in passing, is whether this is appropriate for a report under Rule 34, which is fully briefed, and the court shouldn't ignore that issue.
Correct.
Obviously, 211-3 is the way these cases should get here. 2 out of the 3 got here that way, and that's the supervisory route that should be used. There's so many questions. I want to start Justice Spina's question, which case goes to trial first? The way I read the statute, it says the court may revoke bail on the prior charge pending adjudication of said prior charge. So the case that goes to trial first is the case that you had your bail revoked on. In our case...
So if there's a murder case that's been scheduled to start 90 days from now, and the bail gets revoked, the obligation is, in the district court on a minor offense, the obligation is now on the superior court to advance the trial of the murder case by 30 days, at least.
I would agree that's the statutory
But you
intent.
know that's not going to happen because you can't try a murder case within 60 days. The defendant is never going to be prepared. But
Or the Commonwealth.
But the Commonwealth has moved to revoke
Maybe.
the bail. They can
Commonwealth
choose
may
another
be
route.
willing to go forward in 60 days, but if the defendant hasn't gone through all the motions to suppress, et cetera, the defendant isn't going to be willing to try the case. But
Mr. Zanini,
how can, why, if the charge in the district court is a minor one, more minor, which it is likely to be, that'll be the one that normally gets resolved first.
Well, I don't think that it's unlikely in our current system for anything other than the most insignificant charge to be resolved within 60 days of arraignment.
Right. That's
So there's a time frame here. There's a presumption by the legislature, which is exceedingly difficult to meet in any court. At the end of the 60 days, though, the question is, for instance, in the Superior Court murder case, let's assume the defendant, for whatever reason, was out on bail. Now he's gone out, he's shot someone else. Let's assume the person lives. And the district court revokes the bail. Now the district court judge reads it to say pending adjudication. So, the first question is, where's that body going? What does the district court issue a minimus to do? I suggest the minimus has to be to send him to Superior
That's
Court
what you
because the
suggested.
Superior Court has no idea bail's even been revoked. unless the DA learns of it. In a murder case, they typically would. In a lot of other cases, you don't.
I'm sorry, please finish.
Sorry. Well, I want to say that the court that's got to set the bail on that murder case at the end of the 60 days or at the end of the pending adjudication has got to be the Superior Court. They have jurisdiction over the charges. They have jurisdiction over the individual.
Wouldn't they set it the minute he's arraigned on the murder?
Yeah,
But the murder's the first
he just
charge.
picked up a new charge.
You just got a new charge in the
the
district.
murder.
So now he's
the first
revoked.
charge
His murder bail is revoked.
Let's call it
We have seen
manslaughter.
When you say Superior Court, you just mean first, the
The first
court that
The
had
first
jurisdiction
court
of the
has
first case.
jurisdiction over the case, they have jurisdiction over the person. I would suggest, contrary to what my sister suggests, I think there is a changed circumstance that the original court can take into account. Somehow the changed circumstance doesn't cease to exist for all legal purposes merely because bail was revoked.
But at this point, the changed circumstance bears on likelihood to appear as opposed to other considerations. Different consideration.
Correct. And
Changed
the
circumstance, but
the
different.
commission of a new crime certainly is, renders it less likely that someone will appear.
That would be the
because
argument.
they've got the increased sentencing facing them. Also in
Mr. Zanini,
response.
Let me ask
Sorry.
you this, and I'm really trying to, I suppose the Commonwealth has a number of options. You will seriously endanger any person in the community, so the legislatures, it's almost, it's akin to the language that says you can hold somebody, the sort of dangerousness, you can hold somebody without bail, notwithstanding all the jurisprudence about bail is really to ensure that somebody shows up at trial. The legislatures provide an alternative that if you don't want somebody out because they are a danger to the community, why wouldn't, if you have a very serious crime, why wouldn't the Commonwealth just proceed, as it were, in parallel, on whatever the more serious crime is? What's the advantage to the Commonwealth, given that it's very difficult to get even the most de minimis case, and no criminal case is de minimis, tried within 60 days? What's the advantage to the Commonwealth of revoking the bail if you could get more serious, higher level of bail?
If you could have them held on a
you
preventative
could hold
detention.
them-
58A versus
A
58.
58A.
Well, I think there's three different things you can do. One is the...
No, what can you, not what can you do, but if somebody is
What's the advantage to
seriously
the Commonwealth?
endangered- if
You
you
have
s-
efficiency. At the first appearance, you can move to revoke the bail. You know that a bail warning has been given, that the person can be
Well,
revoked
that's really,
if they
that's the
violate.
sort of Paquette contempt kind of argument. In other words, what I'm saying is, if you look at the seriously endangered, that's pretty strong language. That's fine. Why wouldn't you just do a 58A? And include within that, oh, by the way, this defendant has already been charged with, would that not be admissible evidence at the
Well,
58A hearing?
Oh, I think it would be admissible
Absolutely.
evidence.
Yeah, but 58A, you'll only get to hold them for 90 days, so all you get is another 30 days, which isn't very long in the scheme of
Right,
things, the
and
way
then you have
trials
to-
go.
Right. And then you have a new bail hearing.
And then you have a new bail hearing.
Right. And I think in this case, the case should work the same. You have a new bail hearing at the end of the 60 days.
In
But
which
the-
court?
In the court that has jurisdiction
first court.
over the underlying
The first
charges.
court, okay.
I can't
let's-
see...
So the-
Forgive me, why would you want to have it, let's assume that the first case is the less serious case. The first case is the, snapping, an antenna or something. And then you've got a very serious case, name any one of them. Why would you want to have the bail hearing in the first, if it's a district court as opposed to,
That's the case that the bail's been revoked on. So that's the issue.
That's the case
On the
that
second,
doesn't- That's the case without a bail order.
without a status.
There is no bail order.
Right. Whereas in the more serious case, if the more serious case were the second case, you would have asked for appropriate bail to be set on that case, and then a revocation on the first case. So the only open question at the end of the 60 days is the status of the revocation order. So indeed, I think you're right. It should go back to the court that has jurisdiction over the underlying case. But should we require that that the person be returned to that court within 60 days or at the expiration of 60 days? I mean, should this be sort of allowed to systemically sort of plow along inefficiently, or should the bail, the minimus, order the return of the defendant to the court?
You need some kind of order, some kind of direction from this court. Since the legislature intends a trial within 60 days, And since in the case of Pagan, for instance, I find it sort of, it's mind-boggling to me that Pagan, whose bail was revoked on a Superior Court case, so that whether we like it or not, he was going to go to trial on a particular date, he somehow comes back to district court. Why? Because the sheriff's folks put him in a van and drove him back to district court on a day he's supposed to be going to trial in Superior Court. Well, why wasn't he in Superior Court that day? If he had been simply brought to Superior Court, the Superior Court judge would have said, Mr. Pagan, nice to see you back. Let's have a bail hearing.
What are the mechanics of that? If you have different counties involved here, and the revoking court revokes the bail on, let's say, Norfolk County, and he's just been revoked in Suffolk, and he has a Norfolk County case, the original case. What does the new minimus say? What does the revoking minimus say? Does it direct him to be held in Norfolk County? Does it direct him to be held in the Suffolk County Sheriff's Department? Does it say go back to Norfolk County on a certain day, or does it say nothing?
I think that's a great question.
The courts really don't know what's happening when bail is revoked, do they?
No, absolutely not. And given the volume of cases, sometimes the DA doesn't know, sometimes the defense lawyer on the Superior Court case doesn't know that a district court revocation just happened. And so nobody knows we're supposed to go to trial in 60 days in some cases.
Well, the governor's letter, it seems to me, whether or not one views that as adequate statutory history, really lays out what is happening here. And it's a mixture of saying, one, there seems to be a problem that people are released on bail, are charged with other crimes, released on bail, are charged with other crimes, released on bail, are charged with other crimes. And it appears that the seriously in danger really goes to the fact that somebody is a habitual criminal, which takes it a little bit out of 58A, correct?
Right.
And at least in the governor's, language, it was to push for a speedy trial. Now, I don't know whether 24 years ago, 25 years ago, one could get a speedy trial within 60 days. Do you happen to know whether the new criminal time standards that have been implemented in either the district court, the BMC, or the Superior Court would come anywhere close to being able to meet the 60-day statutory requirement?
I don't think so. I can't speak definitively. I didn't review them before today. But
So
I don't
essentially
think we're
what we're
contemplating
saying
60
is
days.
that if we interpret the statute as it appears to require that we do, namely that it's in essence a speedy trial statute, it really doesn't make it's not feasible, correct?
It's often not feasible.
Well, I am troubled systemically about saying that when you get a revocation, you're going to be pushing what may be a series of very serious cases, but you don't happen to be dealing with habitual offenders, that those somehow get precedence unless we can deal realistically with what happens at the end of 60 days, correct?
That's
In
correct.
essence, well, let me ask a question, Mr. Zanini. If the legislature has said to this court, 60 days is the outer limit, that we want people incarcerated for what may not be separately seriously endanger the community. If it's a separate seriously endanger the community, I've got a 58A. But I've got these habitual criminals who sort of endangering the community, not because one particular thing shows that they seriously endanger, but because they keep doing a number of lesser crimes, and has said, but we only want to revoke bail for up to 60 days. Doesn't that suggest that thereafter they should be out on some kind of bail, perhaps until they commit another crime? And what do I do with the 60 days?
Well, I would agree with that. I think what you do is you make sure that the individual is brought back before the court where the first case is pending and has a bail hearing. And
But
the
then
question
you
is-
can't, then it would seem to me, and I'm just thinking out aloud, that you can't consider as evidence the fact that he or she committed a crime before he or she was incarcerated, you'd have to look at perhaps new crimes or disciplinary violations while they were, that might be, otherwise the person...
Why is that?
Why is that? Why can't you can consider? I mean, it seems to me it's much simpler than everybody is making it. If it goes back, as you say, and let's say you're right, that it goes back to the first court that sets bail, that had set bail, the first court takes it into consideration that a new crime has been committed. Now, if it's a very serious crime, the first court will set a very high bail, and that will take care of any problem. If the second crime was a very minor crime, the first court will either say, I'm not raising bail at all, it was spitting on the sidewalk, and that's not serious enough to raise the bail, or it was a minor crime, I'll raise the bail a little bit. And that's the end of it.
I would agree, and I would suggest that, and I think Justice Graney suggested, you could actually have the bail hearing during these 60 days while you're pending adjudication of the charge.
Listening to Justice Cowan, and again, I'm just trying to see where we are on all of these permutations. In each case, she said, reinstate the same bail, raise the bail. I'm talking about no bail,
Didn't say that.
holding...
But that's over in 60 days.
Right, there's a point at which the no bail order
And
And then I can only
ceases to
no bail
exist.
that particular, that's what I was getting at, I can only no bail that particular defendant if I'm under the 58A, which I might be.
But you would have to have a new crime in a new court to trigger 58A all over again.
Because that hearing has to happen immediately
first-
as well. So-
Right, that's the first time
Right.
here.
First
So I
time.
take it the Commonwealth could proceed under 58A if the second crime was sufficiently serious that the Commonwealth simply wanted to do a 58A. Correct?
On the second crime, yeah.
On the
Yeah,
second
sure.
crime.
Yes.
I would hope that we would not be saying to the Commonwealth that if you did a 58, that you are, I'm worried about precluding you from proceeding under the 58A. That's why I asked you, what's the
Well,
advantage?
in theory, we could move on both at once.
No, I know you can.
The advantage is someone with multiple charges with a complaint issued, you've already established probable cause on the new crime. I think that's one advantage. I also think the changed circumstance of the new crime doesn't simply go away because bail was revoked.
No, I understand that. No, I understand.
And in response to one question you asked, I think if bail is revoked, I think the surety can go to the courthouse and say to the clerk, please give me my bail money. He's a really bad risk now.
Well, that's a separate
But that's not been
argument, so
happening, I take it.
we'll leave
Mr.
it.
Zanini, before you go away, I agree with where you started, which is there's chaos out there. So it is our responsibility, hopefully, through statutory interpretation, to bring some consistency to all of this. I hope that we're able to do that. But one question I want to ask you is this. I'm with you that the individual at the end of the 60-day period needs to be brought back to the original court for the reinstatement of bail, the setting of new bail, whatever we term that. What, however, happens when the second case, the case that has triggered all of this, gets dismissed before the 60 days? So the district court judge now, the Commonwealth moves to dismiss the case, but the revocation order is still in place. The statute seems clear to me that the district court judge then is to consider the revocation order.
I would agree. I think the statute gives a limited grant of authority to a district court or a municipal court to affect a superior court bail order. And that limited grant is both to revoke in very limited circumstances and upon acquittal or dismissal to say, well, okay, he was acquitted or the new charge was dismissed, so now I ought to take that into consideration.
Well, the
And
statute makes that very clear, that
Yes.
upon dismissal or acquittal,
And
It
that's
does.
the limitation on the power to revisit or review the
Okay.
bail revocation.
But then the question becomes, does the district court judge simply say, okay, original bail reinstated, or is this now a new bail hearing on a case that the court doesn't even have jurisdiction over?
You know, that's troubling, but I would think since, if we take a murder charge out, for instance, in the district court judge can actually impose bail in a murder case. So I would suggest they do have some authority there that they could conduct a new bail hearing and say we're going to do a new bail hearing even though the charge is pending in the Superior Court. But I think it's the most difficult issue here.
Okay, thank you.
I have one further question, if I may. Just as a matter of practice, are the DAs, to your knowledge, proceeding more with dangerousness hearings or more with these bail revocation hearings?
I believe more with bail revocation here.
Because they're easier to establish?
Yes.
Okay.
Thank you.